Now back to the show. This is You and the Law with Sterling Fox on AM 650.
Welcome back to the program. David Hobbs and Ian Giroday from the Vancouver law firm Hobbs Giroday in studio for this episode of You and the Law. And Ian Giroday, you mentioned just before the break probate and fees. We're going to talk money here. But my question just before we talk about the specifics of probate and how everything gets paid and who gets paid, when you deal with clients and people come to Hobbs Giroday with complaints or with issues, is it always about money? Is it, I didn't get enough dough, so I'm mad? Is that always the case, Ian? Is it always about money?
No. Is it usually the case? Yeah, probably.
Okay.
But sometimes it's about just hurt feelings, recognition. So, you might have a situation where one of the children feels like they just are not being recognized for their contributions or their relationship with their parent.
Okay.
And they simply want to have some modest variation or some recognition of that relationship, much more so than how much the variation is in terms of a monetary value.
Right. And the word variation, again, simply means a will's variation is a change in the word, the language of the will. David Hobbs, let's talk about probate. First of all, what is probate? It's a word that comes up every time we talk about wills and estates. Oh, sure, probate. What the heck is probate?
Well, in simple terms, when a person dies, they have a will, but how do we all know that that's the last will? And so we need some kind of process to satisfy ourselves, or the system does, that this is the final will, and it is the will that should result in the appointment of the executor, and it should dictate how the estate is going to be handled.
Okay.
So the probate is really the process that achieves that determination that this is the final will, and the grant of probate is the order that decrees that this will is the final will of the deceased, and so hence we use the term grant of probate. The other thing about the process of probate is making sure that the stakeholders, the people who need to have notice, are aware of the process and have an opportunity to speak up, to disrupt that process, or to participate in that process. And so it is a process of giving notice to people, and so that they're aware of what's going on, and that the grant of probate will be made unless they speak up and oppose it in some way.
Okay, so and of course it sounds silly almost, but it's a fundamental requirement of this process of probate, Ian, that there's an actual will. There's a physical document present and available that is identifiable as this person's last will and testament, correct?
Not quite, actually.
Oh.
You do probate a will. As David says, you have to give notice to interested parties. That would be the beneficiaries named under the will. And
Right.
it would be anyone who could bring a will's variation claim, regardless of whether they're named as a beneficiary under the will or not. And they can bring forward a challenge and say, no, that's not, that will is not valid because the willmaker lacked the capacity to make that will. So in fact, we're going to end up with no will or an earlier will. Or, yes, I recognize the will's valid, but I'm going to bring a will's variation claim because the will doesn't treat me fairly. But to return to the idea of probate, you actually apply to the court for administration of pursuant to no will as well.
Oh, okay.
And so you go through a very similar process even where there's no will, and again it's to appoint someone to administer the estate and to give the court a supervisory role over the administrator.
Like one of the things, Sterling, that is said in the materials that are filed with the court is that there's been a search to see if there's any other wills.
Right.
and none have been found.
And here you were recommending just moments ago that we should adjust or upgrade our wills several times through our lifetime, every 5 to 10 years, as I recall.
Right.
So it's possible there are multiple wills in a safety deposit box somewhere.
Yeah, so part of the process is the simple question, are we sure that they didn't make a more recent will?
Sure.
And have you done a will search? Another little aspect to it is we don't think this person ever remarried. And the reason for that is because marriage revokes a will. So there's some evidence, basically, no, they never remarried. This will wasn't revoked by marriage. And so there are different elements of proof and inquiries that surround this idea, is this the final will and the one that we should be working with?
And of course, probate also involves fees. Typically, what does it cost to get this grant of probate, to really begin the wheel-turning process of the will?
Well, and I forgot to mention that, but obviously an important aspect of this is the government extracts a probate fee.
Right.
And to do that, they have to have a process that they have some control over, so that the probate fee is properly calculated and paid. And you cannot get a grant of probate until you pay the probate fee, and you can't determine the probate fee until you file an affidavit that sets out the assets and liabilities of the deceased to determine the value of the estate to allow the calculation of the probate fee.
So it's based on a percentage of the value of the estate then?
It's the gross value of the estate, and it's a percentage of that.
I see.
Yeah.
So then if there isn't much in the kitty, so to speak, chances are the fee will be a flat sort of rate that there's agreed to as well, Ian. True?
For the probate fee, there's I believe the number is $50,000. There's a lower rate for the fee for a small estate.
Okay.
And sometimes when you're dealing with a very modest estate, people may not probate it at all because it's just so small that it's not worthwhile to do so, and they may get, for example, the bank's cooperation that there's no point in making someone go through the process of probating this will where the estate only has a value of $6,000 or something like that.
Okay, so in which case then, David, the bank would just distribute the small amount of cash left in the bank account to those named in the will, and that's the end of it then?
Yeah, it's possible. They might be satisfied that you're the executor, that there is a will. It's a small amount of money. They might require you to sign a letter indemnifying them, which would basically say, we'll protect you if what we're all doing here causes trouble in the future.
Right.
And try to simplify and expedite the administration of that small estate. You might sell somebody a car, or you might an old car or something. All these little transactions and little things, sometimes people try to find a way of getting them done, and accepting the risk that there isn't a grant of probate to formalize the authority to perform those transactions.
Is a typical case in 2013, Ian, involving a death and an estate, is it more likely than not that the value of that estate will be over $50,000? Oh,
yes, certainly. That's
especially if there's a home involved.
Right.
I would imagine, right?
One has to appreciate on all of that the vast majority of people who die at an advanced age and have accumulated their life's worth to that point. So certainly if we're in the Vancouver area, the greater Vancouver area, if there's any real estate involved, for example, you're pretty quickly over $50,000. Now, that, of course, brings back the point that there's a lot of estate planning to take valuable assets out of the estate, by way of putting things into joint tenancies and joint ownership and so forth.
And I want to talk about that. We need to take a quick break here, but when we come back, I'd like to pursue that a little bit, because it sounds that it's all perfectly above board and legal, and I don't know whether it is, and I'd like to pursue that a little bit. Our guests from Hobbs Giroday, David Hobbs and Ian Giroday. This is You and the Law on AM 650.
There's more of the show still ahead. This is You and the Law on AM 650.